The Supreme Court started hearing oral arguments in a landmark case that could have far-reaching implications for free speech and social media as well. The case, Gonzalez versus Google, began when terrorists killed Noemi Gonzalez during the 2015 Paris terrorist attacks. Gonzalez's family sued Google for not taking down ISIS terrorism-related videos and even sometimes recommending them. The justices' decision on Section 230 of the Communications Decency Act may decide Google's fate. For decades, Section 230 has been seen as a cornerstone of the internet. It shields online platforms like Google from liability for content that third-party users have posted. For example, under this law, you can't sue Google because its platform has defamatory YouTube videos. The platform itself, Google, isn't responsible for that content which third parties have posted. If Section 230 were repealed, social media companies would lose immunity. A flood of lawsuits would likely bombard them, damaging and changing their businesses. But on the other hand, critics argue the law enables censorship and allows harmful content like terrorism-related content. The Supreme Court arguments, which were supposed to last around an hour, ended up taking 3 hours. The 9 Supreme Court justices questioned lawyers from each side one by one. The lawyer representing the Gonzalez family, Eric Schnapper, claims that their argument revolves around Google's recommendations. They blame Google for recommending ISIS-related videos, not for the videos themselves.
The claim here is about the encouragement of users to go look at particular content. And that's the underlying substantive claim, is encouraging people to go look at ISIS videos would be aiding and abetting ISIS. More on that tomorrow. But if that's an actionable claim, then the conduct here would fit within it.
Meanwhile, the lawyer representing Google, Lisa Blatt, argued that Section 230 doesn't mention how third-party content is organized on the platform, and putting out content always requires some form of organization.
The other side agrees Section 230 bars any claim that YouTube aided and abetted ISIS by broadcasting ISIS videos. So they instead focus on YouTube's organization of videos based on what's known about viewers, what they call targeted recommendations. All publishing requires organization and inherently conveys that same implicit message. Plaintiffs should not be able to circumvent C1 by pointing to features inherent in all publishing.
We talked to attorney Gerard Filitti for insights on today's arguments. Filitti felt the 9 justices were worried about the consequences of taking action on Section 230. They asked many hypothetical questions about what would happen under many different scenarios.
They had a lot of questions about where this ultimately leads and whether this opens Pandora's box to saying that pretty much the search engines or providers like Google, like YouTube, like Meta or Twitter could be liable for pretty much anything. It really goes to the core of whether it's time to set aside Section 230 and whether it's time for Congress to act on it, or whether the Supreme Court can do something with this case to narrow it down a little.
Filitti believes the justices will be unwilling to be in favor of the Gonzalez family. He believes they will punt the situation to Congress and let Congress decide what to do with Section 230.
One issue that came up repeatedly is that they admitted that they didn't understand some of the nuances of how this worked very well. Not the legal issues, but how the internet itself works and how recommendations work, how publishing content and recommending it works, or the chain of decision within a company that says that we will promote content X and not content Y. So this lack of certainty influences how comfortable they are with issuing a ruling.
Indeed, the words "I'm confused" and "I don't understand" popped up repeatedly during the hearing. Justice Elena Kagan even joked that they were a court, not the 9 greatest experts on the internet. Meanwhile, the justices will hear arguments from a very similar case tomorrow. The case Twitter v. Tamnay considers whether the platforms are liable for terrorism-related content. We'll keep you updated.